The book is under contract with Yale in their trade line. So who knows when it will be coming out? It's very, very far from done, but that's the plan. So it's going to be an academic trade book, and that might explain some things a little better, or it might make things just seem more confusing. My basic idea in the book is develops views that I've put forth in a series of articles. I do believe there is law, and I do believe that there are right answers, right legal answers to at least some constitutional questions, including right legal answers to at least some disputed and contested constitutional questions. I take that to be very widely held in the academy. And yet, for my entire career, even when I was a law student, it seemed people weren't very interested in trying to figure out what made the right answers right. So most non-originalist constitutional theory on its face seems to be about what judges should do. On its face, most constitutional theory before the development of modern originalism took the form, judges should do X, or judges should not do Y. It all read as, on its face, practical advice. Originalists, and public meaning originalists in particular, came around and started talking, not from the very beginning, it seemed to me, but started talking in terms of what the law is. They made claims about the law, about legal content. Public meaning originalism, I take it, the dominant strand of public meaning originalism, or most public meaning originalists, as I read them, are advancing a claim not only about how judges should behave or how they should decide cases, but about what the law is. The view is that the law is fully determined by or reducible to the communicative content of the ratified text. That's just the sort of claim that I like. It seems like it is addressing the right question. Most non-originalist theories, it seems to me, not only on their face are not giving an account of legal content, but what they say on their face does not even imply an account of legal content. That's what I argue. I'll argue in chapter 2 of the book, and I've argued it in published writing. So the clearest example, of course, is Thayer. Thayerian deference is a theory of adjudication, and there's no way to infer a theory of legal content from the instruction, don't strike down a law unless you're sure beyond a reasonable doubt that it's unconstitutional. It just doesn't tell you at all what the standards of unconstitutionality are. And the same applies, although less strikingly, for all of the well-known non-originalist theories of constitutional interpretation, not the Dworkinians. Okay, so I think that mostly non-originalists haven't been providing the right sort of answer. I think public meaning originalism does address the right question and provides an answer. But I just think it's the wrong answer, and that's what this chapter is about. It explains why I think that's not a persuasive answer at all. It can't be falsified. You can just give more or less plausible arguments. We're just in the arguments game, not in the disproof game. This chapter doesn't say anything about other types of originalism. Some of them I'll be addressing in other chapters in the book. This is about the view that the law is fully made out by or constituted by or is reducible to the original public meaning of the text. Or in Chris Green's terms, the terminology favored by Larry Alexander and Chris Green, the public meaning of the text is the truth maker for true propositions of law. For my purposes, truth-making language and metaphysical language or determination language amount to the same thing. I recognize philosophically they don't, but for our purposes, there's not a a hair's breadth of distance really between them, I think. So I view those as the same type of view. So then the rest of the book is just going to address, well, if not public meaning originalism, then what? And then I've got this complicated view, familiar to a very small number of you perhaps, I've put forth in published writing. So I'm just going to keep flying it up the flagpole and see if anyone salutes. So that's the basic theory of the book. I really look forward to your comments, your pushback, your criticisms. This is a great conference. I don't know if this particular iteration will be any good, but in general, it's a great conference. And I am really very, very grateful to the Mikes for putting it on and for accepting my submission this year. I really learned so much from being here. I'm very grateful to be here. And in advance, I'm grateful to Will for what I'm sure are going to be really provocative and stimulating comments. So thank you all, and thanks, Will, in advance.
I do believe there is law. I wrote that down. I'm always excited to hear non-originalists say that, because contrary to Mitch's experience, I don't think that's a widely expressed sentiment among non-originalist constitutional law professors in the academy, and I'm always excited to hear more people say it. So I'll just start by saying that's a big thing that Mitch and I agree about. We agree that there is constitutional law, and that that's the central and important question of debates about constitutional interpretation. Mitch makes this point in the chapter, he's made it before in previous work, that there is an important difference between a theory of constitutional content and constitutional adjudication. Right? Constitutional adjudication is a theory of what judges should do. Constitutional content is a theory of what is the actual content of our constitutional law. We hope those things are related in some way, as we'll talk about, but it's too easy to sort of skate by with just a theory of constitutional adjudication without ever explaining what is your underlying theory of constitutional content, what makes something constitutional law, and thus what is our constitutional law. Centering that distinction and, saying that he's going to have a theory of constitutional content is a really important contribution. I agree that's the right question, and I'm excited to have Mitch's book attempt to provide the wrong answer to that right question, because at least asking that right question is a good thing. Now, Mitch and I also agree about a medium-sized thing, which is the specific thesis, not of the book generally, but of this chapter, as I understand it, which is that there is a big difference between text and law, and thus something importantly incomplete about the standard formulation of original public meaning. That the standard picture that the original public meaning of the text is, in and of itself, and only in and of itself, the source of our constitutional law, is wrong, is missing something. Our constitutional law is not just the text, the whole text, and nothing but the text. We agree about that. And so in a way, I'm the wrong respondent for this chapter, because many of you are going to disagree with him more strenuously about some of the positions he advances, where I'm going to agree with him about that. For reasons I've written, mostly with Steve Sachs, I think there is an unwritten law of constitutional interpretation that you can't make sense of the Constitution without, that is not wholly derivable from or reducible to the Constitution's text, and is derived from the unwritten law in our system more generally. And as a positive matter, our Constitution is really the original law, including the text of the Constitution and the unwritten rules that surrounded it, as it has been modified and amended lawfully since then. That's my view. And so again, that puts me, to some extent, as Mitch's ally in this chapter. And so I was tempted to say, actually, I'm with you. We're told that Chapter 6 is going to explain why I'm wrong, but we don't have Chapter 6. So for present purposes, let's just try to chase everybody into original law originalism, where we shall be. And yet, I will confess, despite this, I found myself disagreeing with a lot of what I read in this chapter of the critiques of original public meaning and the original public meaning hypothesis. And I found myself wondering, even if I might think there's something incomplete about original public meaning, that we need an unwritten law of interpretation to make sense of it, and we need unwritten backdrops to figure out what the law is in various gaps in the text, even if I think that, in a way, isn't the original public meaning thesis directionally correct, as my students sometimes say? Like, not quite right, but closer than a lot of other things people say. Might not a lot of the intuitions behind original public meaning still be basically correct intuitions about the way our law works, even if there's something wrong about them around the edges. And I was trying to think of what the right analogy was. And at first I thought, is this the analogy between sort of ordinary Newtonian physics and relativistic physics, where it's like the Newtonian rules are not quite technically right, but a lot of the time they're good enough to work with. But I think that wasn't quite the right analogy. And then I realized the right analogy is actually in Mitch's chapter, which is Australia. Right? So Mitch makes the point that Australia, the landmass, Australia, the state, and Australia, the continent, are not the same thing. Right? They're actually different, and there are important, significant ways in which those are not quite referring to the same thing, even though we might use the same word to refer to them, and so we can get confused and make mistakes if we try to equate all those things. I agree with that. And yet, Australia, the landmass, Australia, the state, and Australia, the continent are pretty similar. They're mostly the same. Our intuitions about Australia, the landmass, Australia, the state, and Australia, the continent mostly map onto one another, and like most of the time for figuring out what's going on down under, our sense that it's all Australia and we don't have to sweat the difference in those things is basically correct. In fact, it would probably be entitled to use a general presumption that they're kind of the same thing, unless you show me this is one of those special cases where those things come apart as an empirical matter. Right? And that could happen. It could turn out that empirically, the government of Australia, the lawful government of Australia, somehow gets sent into exile in Antarctica, and so there's a sort of no real match between Australia, the landmass, and Australia, the government, or something. But that hasn't happened. It's probably not going to happen, and so we don't need to worry about it too much. And in the same way, while there is an important philosophical difference between the marks on the piece of paper in the National Archives, the communication of the constitutional text, the legal enactment of the Constitution, the legal regime set up by the Constitution. That's, again, a lot of what Steve and I have written about in prior work. It's not that weird to think that they actually line up pretty closely. And so a lot of the time, talk by originalist judges and justices, even originalist scholars, that might seem to kind of generally equate those things, might be basically correct, a lot like Australia. And so in practice, I think a lot of the infelicities and sort of technical distinctions Mitch tries to take on may not really matter very much and may not actually land much of a blow against original public meaning. As an empirical matter, under the law of interpretation we had at the founding, the original public meaning of the constitutional text was pretty darn important and pretty central. There were principles of interpretation that sometimes allowed people to bring in other considerations in interpreting ambiguities in the text. There was unwritten law that sometimes filled in the gaps in the constitutional text. But in practice, there's a reason that original public meaning originalists and original law originalists and original methods originalists and original intent originalists actually agree about most of the questions of constitutional law when they agree on what the historical facts were. And so I'm not sure how much of a blow against original public meaning has really landed. And at times I worry that the book is sort of refuting a view that may not be one that anybody actually holds. It may be refuting a sort of a strong form of original public meaning that's not the actual view that anybody actually holds, even people who say some of the things that Mitch quotes in the chapter. This gives me my third point. So that gets us finally into kind of the broader argumentative structure of the chapter, which is very interesting and which I think derives in part from the nature of the book that Mitch described. As he says in the book, the book is operating under the assumption that positions in constitutional theory can't generally be proven or disproven, that they're like Kantianism and utilitarianism and other philosophical debates where you can kind of advance reasons for one theory or another, but that it's hard to really refute or force somebody not to hold them. And so the chapter proceeds in a more, in some ways, sort of gentle and discursive fashion, rather than just trying to fully disprove original public meaning, to try to kind of convince you of things that are missing or ways your intuitions might be misfiring and so on. And it also therefore takes on this kind of descriptive quality as it sort of goes through the history of the development of originalism and sort of picks on particular people who are particularly formative in the development of originalism at particular times. At first, I was tempted to say I found that kind of a almost frustrating ad hominem in places. But as I thought about it, I don't think that's right. I actually think there's a much more charitable reading. I think, Mitch will say in 4 minutes, that he's trying to describe and answer the originalist arguments that actually emerged and actually convinced everybody, and to sort of chart the way in which, what the originalist arguments were, how they migrated from being the wrong kind of question, a theory of constitutional adjudication, to being the right kind of question, how they took on board this kind of implausible view of the standard picture that was intuitive but wrong when we more carefully examine our intuitions, but that the structure is sort of because he's following the history and the development of originalism. Originalist theories of constitutional interpretation started with Robert Bork, Rehnquist, and Scalia, we're told in the first paragraph of the book. So here's my last concern, which I think this is wrong. My predecessor in office, constitutional law professor at the University of Chicago, William Winslow Crosky, would like a word. So he was once the most significant law professor in the United States, and certainly the most significant originalist law professor in the United States. In 1953, he published Politics and the Constitution and the History of the United States, an 1,100-page, 2-volume book laying out the original meaning of every part of the Constitution on the basis of exhaustive research. And he explained in the preface to the book that he was recovering what he called the original understanding of the Constitution, that he thought in many places we had lost our ability to understand the Constitution's original meaning because we saw these words in the Constitution and sort of thought we could intuitively know what the words meant, but until somebody could go through the sources really carefully and construct effectively a founding-era dictionary that would let us translate the legal concepts into the Constitution to the law today, we'd lost what it really meant. And so he set out to do just that in the book. It was an important part of originalist argument. The debates between him and Charles Fairman about the incorporation of the Bill of Rights were one of the first major originalist debates in academic literature that then migrated to the Supreme Court, debates between Hugo Black and Robert Jackson and Felix Frankfurter and others. And for what it's worth, he complicates the narrative in a couple of ways that are tricky. He was a liberal. His entry into constitutional law started with his research about the constitutionality of the Securities Act and led him to writing a 2-volume book with the original understanding of the whole Constitution, mission drift I can sympathize with. He had a theory of constitutional content, not a theory of constitutional adjudication. He was setting out to lay out the original meaning of the Constitution well before the sort of Bork-Berger-Scalia period. So I don't think it's correct that public meaning originalism started with Bork and constitutional adjudication, only later became a theory of content. Now, maybe you say, okay, Crosky, but he's very obscure. But again, I will say, as an original matter, his book was reviewed in over 75 law journals, attacked by everybody from Henry Hart to all the way on down. It was an important part of what our constitutional law was. And maybe you say, well, that's just a different story, right? This is the story that starts with Bork, who starts the chapter. Well, William Crosky was Robert Bork's constitutional law professor. Where did Robert Bork get his ideas about constitutional interpretation? What implicit theory of constitutional content was he working on when he started explaining his theory of constitutional adjudication? I think we know the answer, and I think we know where to find it. And so I'm not sure the entire story of original public meaning originalism really works. Thanks.
Thank you so much, Will. I have nothing to say about Crosky other than I guess I got to go look him up, read him up, and think more about how I want to starting about how I want to incorporate him into the book. So thank you for that. I've got nothing to say about him. I'm puzzled by your thought that Australia cuts against me. I think Australia cuts in favor of me. The magnitude of the departure, the magnitude of the lack of fit or lack of correspondence among the different senses of Australia is less significant than the fact that they're not concordant. That's the importance, I think. Furthermore, over time, the degree of concordance in these three different concepts, the extensional lack of concordance in these three concepts is likely to grow, as we see, I think, with regard to the role of the meaning of the text in our constitutional practice. So that's, we could have Western Australia keeps trying to secede now and again. One day it could happen. There are non-trivial parts of the Australian continent which actually are not part of the state. So I think that the degree of coincidence is less than you do. But in any event, so long as you recognize that original meaning isn't the whole story, even if other pieces are small parts of it, now you're in a very, very difficult jurisprudential situation, which is if you believe in legal content as we do, and if you've got a plurality of determinants, we now confront what I call the e pluribus unum problem. How do we get a singular, unique resultant from a plurality of determinants? That is actually a very substantial philosophical problem across domains of philosophy. It's a significant puzzle in the theory of the structure of concepts. It's a puzzle in legal theory. It's a puzzle in ethics. W.D. Ross, the British ethicist, is famous for his prima facie principles. And to this day, I think ethicists don't really have a good handle on how the prima facie principles combine to make the all-in. So I think it's not so much the magnitude. Once you recognize that over time, a living practice tends to become more pluralistic, I think. And then we have a reaction. Right now, we're in a reaction to that where we're becoming less pluralistic. But there's always going to be that dynamic. And I think because of human needs as they arise and the inadequacy of the communicative content of texts, it's basically inevitable that legal actors are going to reach out to recognize other determinants. So to take Mike Rappaport's question, why did originalists reach these results in the Trump cases? Why? Because pluralism is the nature of our reality. Our reality is pluralistic, and we are always going to see pressures toward pluralism emerge in any type of human practice. So they're recognizing, yeah, we're sort of signed up for originalism of a sort, but prudential considerations have to be given their due. And that's what's going on in the Trump cases, I think, and it's no surprise. So I do think that I think Australia doesn't, you might like it, and maybe it serves original law originalism, but it really doesn't serve public meaning originalism, because I've got no problem in recognizing that lots of original stuff matters. Pluralists can recognize the relevance of the whole range of originalist stuff, which not you, but many originalists have difficulty accommodating. So the fact that original meaning matters, different types of original intentions, that is, original legal intentions, or original application intentions, all matter, I think, is true of our situation. And what we need to do is to come up with an account to figure out how, as I say, a plurality of inputs can yield determinate legal content. What we have before my account on pluralism, the two main pluralistic accounts, are Philip Bobbitt's, which doesn't deliver unique answers, right? Any legal answer is correct so long as it's validated by a single modality. So we just have the situation in Bobbitt's theory in which a proposition is true from the ethical modality, and the negation of that is true from the practical modality, and so on. And then we have Dick Fallon. Dick's not here. Is he this year? I didn't see him. Who has a lexical approach. So I do think that the challenge here is to figure out how a plurality of inputs can combine to produce legal content non-lexically. And that's what I try to produce. But that's not in this chapter. Otherwise, I don't think I have any. Although you start off by saying that there are many things in the chapter you disagree with, you only gave me a few of them. I'm sure that's just the tip of the iceberg. But of some of the things you said, including the Krosky stuff, just maybe you're right about that, and I have to go back and figure out which of the main figures in the tradition really warrant more airtime in the book. But I appreciate that.
My question is about your characterization of what originalism is that you're criticizing. I want to know, how much does your thesis depend upon, and how much would it be affected by, how much does it depend upon the claim that originalists, public meaning originalists, believe that legal content is created solely by the text? And how much would it be affected if it turns out that public meaning originalists do not make that claim, that public meaning originalist is a theory about what the meaning of the text is, and that's a descriptive claim, and it makes a normative claim about why that meaning should take priority over other sources of law. That's a normative claim, but it does not make the claim. How much would your thesis be affected if original public meaning originalists did not make the claim that you repeatedly made in various ways throughout the entire chapter and again 2 times in your presentation today? Would your critique of originalism be affected in any way?
Okay, first, the lexical priority stuff from the bunk paper seems like it has sort of disappeared. So just kind of underlining I think the spirit of what Randy just said. It seems like originalism is the thesis that sufficiently clear original meaning trumps other stuff, but there could be other stuff. So the exclusivity claim, I didn't recognize it as my view anyway. But I did want to talk, because Evan isn't here and Mike Paulson isn't here, so I wanted to talk about the oath stuff. And Will's told me he wasn't going to talk about the oath. So I did want to first defend the oath. It has been made before. So the first couple pages of our Penn State paper, we talk about Eli Moore in 1837, Jacob Howard, 1862, Thomas Cooley, his treatise makes the argument, and it gets quoted by the Four Horsemen in 1937. So, I mean, this argument has been made a bunch of times. Why didn't Story make it? Well, he was in search of a theory about certain things, but the disputes going on in 1833 were different from the ones today. Just because it didn't occur to Story to try to ground something in the oath to resolve the controversies he had doesn't mean it can't resolve the kind of things that Moore and Howard and Cooley and Evan and Mike and I and some others think it does. Like Will, I'm very curious what's in Chapter 6. So you promised in Chapter 6 to refute my version of the oath argument. So my Notre Dame, so I think might be useful to just distinguish what's going on. So the Penn State piece that I did with Evan, the argument there is that our Constitution is old. Okay, so the original Constitution, that nature is still the nature of our Constitution today. The Notre Dame piece from years and years and years ago is about all things like we the people versus ourselves, now existing, that kind of stuff. And in that paper, I actually say the word this by itself is not the only thing that causes the Constitution to be self-referential. And the Confederation, I think that's a great example. This union is not textual. But we have this phrase, this union, in Article 4. So there's a lot more into it besides the word this. I'm curious whether Chapter 6 goes into detail about all the stuff like now existing, we the people versus ourselves, and that kind of stuff.
Yeah, thank you, Mitch, for such a deep, illuminating, and clear book. 2 things. The first is just the way the chapter reads to me. I think many readers will assume that you are identifying common ground between all self-identified public meaning originalists, but in fact you are picking and choosing. You're taking statements from some public meaning originalists, and of course there are directly contradictory statements for others on things like the standard picture and whether or not the text is fully determinate of constitutional content, et cetera. So I just think that it would be a service to your readers to identify the range of opinion on those issues and recognize that public meaning originalism has encompassed a variety of views on those questions. Second thing is about your Scalia argument at the end of the chapter. I just don't think the argument you make works here, that the fact that Scalia did not reach or advocate for results that he would politically prefer that doesn't prove that he was non-ideological, because only cranks would advance those results. So the first thing I would just say is that the way Scalia saw the world, there were two alternatives. There was originalism and, you know, what we might call the super legislature theory. And so if he was in fact willing, if he was in fact uninfluenced by originalism when it conflicted with his political desires, then the theoretical option that he saw open to him would have allowed him to reach that result. And I don't think that Scalia was afraid of being a crank. So I just don't think this argument works. I think it's facile, and it just does not. The conclusion you reach does not fall in opposition to Wayland. Just doesn't follow from the argument you've made.
Mitch?
I think it works. Here I appeal to Jack's on the wall, off the wall. I understand that Scalia is not averse to being a crank, but still you have to make claims and you have to reach positions that are on the wall. And I think he was sufficiently well socialized as a lawyer that he wasn't making arguments completely off the wall. So I think in response to Wayland, actually, my arguments there I feel pretty good about, but we can hear, I'm happy to chat with you outside and give you an opportunity to persuade me that I'm wrong about that. I don't know how important it is, but I guess I think that I guess I'm with Posner on this, yeah. Look, this isn't a book about originalism. So Chris thinks that I'm going to be talking more about him in chapter 6. I don't think I'm going to be. There's some Will and Steve in chapter 6, and it's not all going, but it's not, you know, focused on them. This isn't a book on originalism. This is a book saying, here's an important question. We don't have enough answers to this question, and the only answers we have are originalist and natural law, I think. I cannot think of any good non-originalist, positivist answers to the question of content. So I think it's a really important question, and I'm giving originalists their due, I think, in recognizing the importance of that question. But it's not about originalism. As it is, public meaning originalism, or at least the center of gravity, it seems to me, of public meaning originalism, will get more attention and more airtime in this book than any other theory other than my own. So I'm giving a lot of time to it, but that's not this book. To go through all of the forms of originalism. I don't go through all of the non-originalists. And this is an academic trade book. As it is, it's going to be too long. I'm going to be looking for places to cut, not so much looking for places to make the originalist case yet more nuanced, and, like for an academic book. It has a trade-ish audience. That said, skipping Chris for a moment, going to Randy's question, and this I know is Larry's concern as well. Both of you guys have a concern that there aren't enough public meaning originalists who hold the view that I attribute to them. I guess I should put more stuff in about the lexical possibility. But it's not as though I'm just making this stuff up. So I quote a lot of people, and one person I quote, who I think says very clearly the law is the public meaning of the text, is Justice Barrett. So it's not like I'm just finding nobodies and saying, here's someone who says something that's useful for my purposes, so I'm going to quote them. We've got lots of passages that say the law is the public meaning of the text. You're not signaling me, okay. But yeah, it is somewhat more nuanced. We'll have occasion when you're when your paper's up, will give me an opportunity to say a little bit about where I think the two of you are non-identical to the view that I'm criticizing here, and why I have some discomfort with your view, Randy, which is that I have a hard time figuring out exactly what you think determines legal content before judges get their hands on it. Actually, I find this more of a challenge in Larry's work than in Randy's work. But in Larry's work, I do have a little bit of difficulty, or more than a little bit of difficulty, finding out what you think is the account of existing legal content, the legal content that pre-exists judges' act of construction. Maybe we can talk a little bit more about that. But I agree, yeah, there is, over time, originalism getting more and more fragmented, including public meaning originalism is getting more and more fragmented. And it's not true that there's a single view that everybody who calls themselves a public meaning originalist adheres to. I acknowledge that, and if the chapter suggests otherwise, then I will revise that. But insofar as the worry is that no one really has that view, I guess I just want to say, I think I quote enough people and important people who express that view. And I think that's the view out there in the public square, as it were, more than in the academic debate. So you folks are going to be very, very highly attuned to all the nuances here. But I think what really drives the explosive growth and influence of originalism is this very simple, very clear, and I acknowledge very intuitive, although I think wrong, but very clear, simple, intuitive view about the law. Hey, if we've got authoritative text, then the law is what the text say. I think that's a very intuitive view, and I think that's a very powerful view outside of very highbrow academic conferences. So I guess I'm going to stick to my guns there and say I think that's an appropriate target for the book.
I promise not to jump in every time, but I will add one comment, which is in a book not about originalism that then decides to talk about originalism, there is a question of what originalists to talk about and why. And I think one general question is, would it be best to address the best arguments rather than some other set of arguments, and to try to sort of steel man to steel man, and then ask yourself, are these the best arguments I'm addressing? And if I'm not addressing the best arguments, then should I at least tell the reader why? And maybe the answer is because this is a highbrow academic conference, but the best arguments stay in this room and never migrate out. But I think there's a sort of question about that. An alternative would be to save a lot of words by cutting chapter 3.
As it happens, I underlined exactly the same sentence Randy asked about, and was going to ask something very similar, but I think it would be more helpful if I just offered you, Mitch, what I consider a more accurate general view of what makes an originalist. I do not think the definition of an originalist is what you write here. What I think the minimum content that you have to believe if you were an originalist is that the courts should never interpret the Constitution in a way that we know was not the original meaning of the Constitution. Oftentimes we don't know, we look to other things, but we should, if we do know something, we should never go against it.
You're welcome to sort of interpret, what I write however you want. I'm not going to pull I know my own mind kind of a spiel on you. So instead, I'm going to ask a question similar to Randy, which was basically my question, but in the frame of I'm not sure you get the non-originalists right. And so, for example, when you're talking about my argument, you respond to it by saying that my argument only makes sense if it's non-originalists must deny that the words in the constitutional text had public meanings when the text was enacted, but non-originalists do not deny that. Of course they don't deny that. That's not the claim that Gorsuch, Berman, Lawson, others are responding to. The claim they're responding to is a claim that lots of non-originalists make, that you can ascribe a meaning, some other than the original public meaning to a text, for example, contemporary public meaning. And these aren't dummy non-originalists. Cass Sunstein, Fred Schauer, David Strauss, all have said something along these lines in terms of contemporary public meaning could be an interpretation of the text. What we, I think, at least I disclaim or argue against, is the idea that doing that thing is interpreting the text. It's doing something else. Constitutional creation, judicial lawmaking. It is that step from claim 1 to claim 2. So that's what I think we deny, that doing that thing, saying you can ascribe some meaning other than the original public meaning to a text and call that interpretation, I think is wrong. And so to put my comment in the form of a question, to the extent that legal content has a delta from original public meaning, what does that delta have to do with the Constitution, with the parchment under the glass at the National Archives?
I guess two kind of smaller points. In the chapter, you say, well, there's Brown and there's Loving, and like maybe originalists have an answer to those. There's, in the footnote, it's a nod to David Upham. But you seem to think that those are just, and your criticism seems to be, well, those are just right. And if you leave that up in the air, there's something wrong with your theory. Now, for me, the rightness or wrongness of those is the conclusion that you reach. It's not a premise. And I can certainly understand you might just assert that if you had like a moral reading of the Constitution. Since yours is a positivist there, I just wasn't sure. I mean, you weren't trying to show it in that chapter, but I'm just curious how you feel that that's just right. And I assume much of the book might get into that. But I thought I would ask about that. And then I also wonder, when going through the sort of history there, and you're talking about Scalia and various people, Bork, I think it's important to contextualize it a little bit. They were involved in a debate about like what should be done, and they were responding in that debate. And it's not so much that they, I mean, it may be analytically correct that they didn't focus in on the law question or the content question, but I think it's important to recognize that they were involved in a debate where the question was what should be done, and that's why the theories took the form that, or their pronouncements took the form that they did.
Great, thank you all. I agree with that. It's not a criticism of them. I start off, I talk about Bork at some length in chapter 2, and I give some history leading up to Bork and show that that's the discourse at the time. So I agree they were responding to other people saying this is how judges should behave. So that's how they were speaking. That's why it wasn't at day one, putting Kroski aside, which I ought not to, I gather, but at least it's not the case that Bork is talking about content, and it's not, for the most part, the case that Scalia is. They're both talking, for the most part, about adjudication, slipping a little bit into content. A focus on content emerges a little bit later. I think that you and I would agree about that then. When I say that, I don't believe that Brown and Loving are just right, that these are fundamental premises, that just, the correctness of these are axioms that we can just help ourselves to. I can see why you might think that from chapter 3. In chapter 4, I will go back and explain the use that I make of them there. I find it it's already a long chapter, and I think it's going to be helpful expositionally for it to come in afterwards, but it's the same move that I've made in previous work. It's basically coherentism. So the view is, if you start by thinking these seem legally right, because we all start with priors. We have various beliefs about correctness of theories, correctness of cases. There's no alternative to coherentism, I think. And then I explain that in chapter 4. But I absolutely do not believe that these are things which cannot be wrong. I'm just here relying a little bit on the fact that I expect my readers to believe that they're correct, at least presumptively. On Elon's question, yeah, the term constitutional interpretation is ambiguous. It could be that we're trying to figure out the communicative content of the constitutional text, or it could be that we're trying to figure out the existing law, constitutional law. I've, in a number of papers, announced my preference for the latter meaning. So I think when we're engaged in constitutional interpretation, we're trying to figure out what the existing laws, that the activity of constitutional interpretation, as I conceive of it, is the activity of ascertaining existing law. And then what are the determinants, what are the ingredients that help partially constitute existing law? Well, that's a theory of constitutional content. I think original meaning is one of the determinants. I think contemporary meaning are others. I think it's actually a mistake to think that there is only one sort of meaning that a text holds. I think that texts have various types of meanings. I've argued for that elsewhere. So I think there's an original public meaning of lots of texts. And I think there's a contemporary meaning. There may be other types of meanings, the morally best reading. And then the question is, how do those different types of meanings and other sorts of things combine to generate law? And Mike, I think that when you said you don't like my definition of originalism, I do think that it's a definition of public meaning originalism and then only a stipulative definition of originalism. So I say this is what I take to be public meaning originalism, and then I will use the term, except for when I say otherwise, I'll use the word originalism to mean this theory. So that's not just a description. I'm not there saying everyone who's an originalist holds this view. But I do gather from your and Randy's and Larry's comments that you guys aren't satisfied with that, and I'll have to think about how I make the view more nuanced in a way that more of you folks can live with, but also that's faithful to my read of the terrain. But I take the point that you made. Notice that in your proposed definition of originalism, though, you offered a theory of adjudication, not content. Judges should never decide a case that's not consistent or in contradiction to our known meaning. So that would be, if you think that really is one view which all originalists could share, then what you are offering is an originalist theory of adjudication, but I, of course, am looking for a theory of content because that's what I think many originalists warrant a lot of credit for insisting on the importance of content, as people on my side of the aisle have not and have denied the importance of content over and over. So I guess that's my view there. I'll stop.
Well. Okay, our next three are Squircle, Defenestrate. Sorry, that's an inside joke for those of you who read the paper. Next three are Martin David Kelly, Rob Gellis, and John McGinnis.
Thanks. So there's a lot that I really liked about your chapter, although in common with others, it seems I'm more interested in what comes after this chapter, and in particular, what you teased us with in the introductory pages, that you've got a new articulation and defense of pluralism. One of the things I really liked is that you make a point of noting that it's a category mistake to identify the law with text, although I would disagree with you in your characterization of it as an event. So I would say law is something created by performing an action, performing the act of adopting or enacting the text. Yeah, it's crudest. They're not called events of Congress. They're not called texts of Congress. They're called acts of Congress. I also really like that you looked beyond the US, although I've got some quibbles with what you did there. Possibly the most serious of them was your reference to the Canadian Privy Council, which a less charitable reader might take you to think that the Privy Council was a Canadian institution. And I also really like that you drew a sharp distinction between theories of content and theories of adjudication, which is something that I do in my own work. But I was puzzled by your claim that the original intention originalists were offering a theory of adjudication rather than a theory of content. First, I was puzzled as to what work it was doing for you. So is it just a freestanding claim in the history of ideas? If so, that's not uninteresting, but if there's some other work that it's doing for you in your argument, then maybe that's worth bringing to the surface. And if not, then maybe, especially if you're trying to reduce the length of the book, that might be something to leave out as a little bit of a distraction. Not least because I didn't really think your argument was persuasive. So you give us a few selected quotes from a few originalists, and I wasn't persuaded by the quotes that you gave, that even if your claim is correct, that your argument for it makes good on that claim. And the quotes that you did give seem to be about drawing a distinction between content and application. So my question for you relates to that, because again, I think you're right to distinguish content from application, but I also think that they are closely related. So I guess my question for you, or general question, is what do you mean by content? What do you take content to be?
All right. I guess my first question is something that I feel like we've been. My first question is something that I think we've sort of been hovering around in many of the other questions that have been asked, and it boils down to: do you think that that legal content can contradict communicative content? But something that you mentioned in one of your answers to Elon earlier was a contrast between communicative content and existing law. So I was kind of wondering if in your theory of what existing law is, you're kind of denying or breaking with the interpretation-construction distinction, and if that sort of gives you a sense of, or cuts around the question of communicative content and legal content. And then I had a second kind of an observation on your discussion of Justice Scalia at the end. You point out that he was often not altogether generous to some of the objects of his criticism, some other lawyers and judges. And as kind of an outsider to the legal profession, I just wanted to note that doesn't seem especially unusual. It seems rather common for lawyers, judges, professors to make sometimes ingenuous characterizations of their opponent's argument, maybe a product of zealous advocacy. But I guess I wondered if that is just part of legal culture. Does that sort of shed different light on your reflections about Justice Scalia? Thanks.
So thanks for this, Mitch. I want to pursue this issue of coherence. Perhaps you'll pursue it more in another chapter. So you're sitting next to someone who's actually argued that originalism is our law, and argued that actually the justices refer to originalism, and so there's a sense in which that provides a kind of coherence. I think that's maybe a little exuberant. In other words, that he shows it's a contender for our law, but maybe not exactly our law. And of course, then you have a question. You say, well, we have all these data points, and you point to a lot of problems for originalism, Brown, and that's one way that it's hard to account for those decisions. And they may seem important to account for, but isn't that only looking at one side of the equation? Why wouldn't one look at the question of, well, all the efforts to do non-originalism that might be sort of embarrassing, all of the Plessy, all the death of the Reconstruction amendments through a kind of systematic non-originalism. Also look at the other questions. Well, how much did these matter actually? For instance, bowling would obviously have been corrected quickly by Congress. We can imagine an amendment process working to deal with child labor and having more specific amendments and maybe going better. So these are kind of, it's very hard, I think, to draw these conclusions is what I'm suggesting, just on coherentness values, but they maybe require counterfactuals and all sorts of data points that you haven't discussed. And does that require us to, so long as we have theories that are plausible contenders like originalism or some sort of modality view, maybe that requires us to look at some more overarching moral theories. And of course, originalism, there have been a lot of theories offered for originalism for that, and I'm sure there have been a lot of theories offered for non-originalism. So that question is coherentism even ultimately enough?
Thanks, John.
You're welcome.
The book doesn't proceed as though after chapter 3, originalism writ large, or even a form of public meaning originalism, is now disproven. So I start with the idea that it's quite intuitive. It being the idea that the law is the public meaning of the text, or the communicative content of a text makes out the law. I take that to be a very intuitive idea. I'm surprised that so many people want to run from it. And then I cause trouble for it. And then, you're right. It's all compared to what? Do we have a better account of legal content? So then I'm going to offer something. And then I'm going to defend that, and I'm going to give lots of examples. And then I hope at the end of the book, then people think, okay, I started off perhaps thinking public meaning originalism seems very plausible. Then I saw some difficulties with it because it doesn't seem like it's very plausible to be a universal thesis, although it could be. And then difficulties from the American context, all of which I hope leaves people more open to a different account of content, a pluralistic account, which I think is very faithful to our experience, pluralism. And so then maybe they'll think, yeah, all on balance, given all of the criteria that make for net plausibility. Basically, I think that our views here are always a battle for net plausibility points. Which view has more plausibility than any of the alternatives? So that's sort of the process. Here I'm causing trouble for it, and then I'm going to offer something else. It's not like now we've seen originalism is false. Let's see, on Rob, you may have had something else in which I didn't address, and I'm sorry if not. On Rob's questions, yeah, can legal content contradict communicative content? If that is a question of general jurisprudence, the answer is yes, absolutely, unequivocally. Of course it can. And that's true, and there are examples from all sorts of legal systems. I think that's true of our legal system. Now, the example I'm about to give might cause me to get hit by my neighbor to my right, but I think our 11th Amendment jurisprudence is inconsistent with the communicative content of the text. So, yeah, it can, and whether it does, it's an empirical, a theoretically laden empirical question. One ought to expect, it seems to me, that we get more factors that are ingredients to legal content over time. Basically, we start narrow, maybe we start with the idea, legal system born today, we're probably going to have just one consideration. The meaning of the text is the law. And then what happens is it causes trouble in that if you stick with that theory, then you're going to get some outputs which no one can live with, or enough people can't live with. And then the people with power, judges, are going to start identifying and endorsing, internalizing different types of factors or modalities. That's how we get bushier. And then what happens is it looks so far removed from, it's too pluralistic, giving judges too many degrees of freedom, too far departure from the original meaning, and then we're going to have cutting back. We're in a cutting back stage. But we're always going to have those sorts of pressures if you think of law positivistically at all. Martin? I didn't catch all of what you said, so maybe we can talk afterwards. I didn't catch the thing about the Privy Council. You attributed to me the view that original intent originalists don't give a theory of content. I don't mean that categorically. Berger, an original intent originalist, did have a theory. His view was a theory of content and adjudication. Mies was just a theory of adjudication, I think. So we have at least one original intentionalist in the room. I think his is a theory of content. So I don't have a categorical view that original intent folks can't be content folks. What's most interesting there are the different objects of intention. That is it the intended words, the intended meaning, the intended rule, the intended results? These are all different objects of intention, any one of which could be the intended thing, the object of intention, which matters for purposes of determining legal content, it seems to me. So I don't think that I expressed the view that you thought I did, but maybe I misunderstood what you were attributing to me. You ask, what is content? I take content, legal content here, to be general legal rules, so norms of a general sort. So it wouldn't be, do not X would be the paradigmatic legal content if you replace X with an act type.
Oh, okay. Well, as you rightly pointed out, I have perhaps the most out-of-date view of originalism. It's the intended meaning of the words that counts, not the public meaning, if that differs from it. It's the meaning of those who have the authority to write the constitutional terms. Now, I think that's you call that one of the monistic views, and it is. That's what the Constitution means. It means what the people who authored it intended by it, what their intended meaning was. All the other things that you bring up seem to me to be, they may be plugged as at constitutional stature, but they're not. They have no basis, unless what we say is that what we've done is we've accepted a constitution that is different from the one that appears on the paper, that we've accepted a different constitution, and that what we have in these cases is judges applying that constitution as opposed to the one that we normally think of as the Constitution. Now, I don't know, it may be that it's a bad thing to try to follow a constitution for more than 20 years or something. That just it's out of date. But as far as I know, that's the Constitution we have. It was authored at particular times by particular people who had an intended meaning. Perhaps they didn't have an intended meaning, in which case I would say it's gibberish. But if we did, I think the important thing is to be frank about what we're doing here. Are we interpreting what the authors of the Constitution meant? Or are we doing something different? And I think it would be very hard to publicly announce that we're doing something different.
Thank you for the paper, Mitch. I agree with Randy that it was written really beautifully and it was enjoyable to read. One question I have for you is you're offering as data points from a positivistic point of view ways in which judges are deciding cases or looking for legal content that might involve inputs other than original public meaning. And so you're pointing to that for your hypothesis that demonstrates from a positivist lens that these other inputs are part of legal content too, as I take your argument to be. So far, so good. So I guess my question for you is, what if, there's two potential explanations for those sorts of decisions. What if those are decisions that are wrong? It's not as though you have canvassed enough decisions that you can authoritatively say, there are 90% of these cases and only 10% of the originalist, only original input cases, and so therefore our rule of recognition clearly demonstrates that multiple inputs are the law. The fraction might in fact be the opposite if we did empirical research, in which case Will is right that originalism is our law. It might also be the case that it's split, and maybe it's close to 60-40, 50-50, in which case a positivist might say, maybe we don't have a clearly defined law of interpretation. It's sort of up for grabs. There are some strong contenders for what is our law of interpretation, and originalism is among them, and maybe the multiple modalities is among them. But I mean, Hart would say you have to have a certain level of consensus that's pretty high for it to be our law, and if we don't have the consensus that you're suggesting, then maybe you can't claim it's our law either, which would then maybe require you to have normative arguments about why that ought to be the law, and maybe that's coming later in the book. So I was just curious if you have such a normative argument. You have a hypothesis on page 49 where you say, here's the hypothesis you generate: all else equal, factors or inputs other than a legal text's fixed meaning will have more influence in legal thought and judicial decisions the more difficult it is in that legal system to amend or revise the text formally, and the greater the distance from its promulgation. But one might think that normative arguments would cut the other way, that the harder it is to amend text, the farther we are from the text, the more troubling it would be to give judges the authority to then change the law by imbuing it with whatever different modalities they think are relevant. The democratic deficit, for example, is greater with a text that is hard to amend than a statute, for example, that judges might be able to interpret, and Congress can more easily come in and say, no, you got it wrong, and so there's less need for caution there, which is something that our Supreme Court has said.
I'm wondering if maybe you're running together two targets in this chapter. So the first would be a version of public meaning originalism that doesn't ascribe any legal significance at all to the drafter's intentions. And then the second is the version of the standard picture as applied to the Constitution that identifies the Constitution's legal content with its communicative content. So the communicative content of a text just is whatever meaning the author of the text intended to convey by means of the text. So on the standard picture, the author's intentions regarding what, or the drafter's intentions regarding what meaning to communicate do have legal significance. In fact, that's like the whole ballgame. So the standard picture is going to agree with public meaning originalists against some of the old style original intent originalists, insofar as the standard picture is going to agree that the author's intentions of, like, further intentions about what to accomplish by means of communicating a certain content do not have legal significance. But the author's intentions about what to communicate do have legal significance. For the standard picture, that is what legal content consists of. And I think this distinction matters because you suggest, like, I think some of your arguments might not work against the standard picture, even if they do work against versions of public meaning originalism that don't ascribe any legal significance to any form of drafter's intention. So, like, for example, you suggest that scrivener's errors, or the practice of correcting scrivener's errors, is inconsistent with a commitment to the standard picture, but I don't think that's right. Actually, it's like really easy for the standard picture to explain the practice of correcting scrivener's errors. Whenever we correct a scrivener's error, what we're doing is we're saying, well, based on the context, it's really obvious what the author of this text meant. The author of the text meant whatever meaning would be expressed by the text once we correct the typo. So nothing about the practice of correcting scrivener's errors presents a challenge, as far as I can see, to the standard picture that identifies legal content with communicative content, although it might present a challenge to some versions of public meaning originalism. So I think it might be helpful to tease apart these two views and be clear about which ones various arguments you present are supposed to be targeting and supposed to be arguing against.
Stephanie, I don't talk of the law of interpretation. That's Will and Steve talk. I'm interested in the substantive law, what the law is that interpretation is trying to discover. I'm not interested in the law governing the interpretation. So I'm thinking that there's law out there, the substantive law, that interpreters are trying to discover. I'm not interested in the law of interpretation itself. I'm also not Harshan. So I do think that the account of legal content attributed to Hart, first of all, a lot of Hart exegetes don't think that he was really up to a theory of content. But insofar as he was, I don't think that the view attributed to him or the view that he had is the right view. So I do put forth I have already, in published work, put forth a different positivist view of legal content, which I won't say anything about now, but just to say that I agree that if I'm assuming Hart, that causes difficulties for me that aren't produced if I'm not assuming Hart, I think. Charles, you said a lot there, not all of which I followed, and insofar as I did follow, I don't think I disagreed with, except I don't think that the Scrivener's errors cases cause trouble for the standard picture. If I said so, maybe you can point out where I said what you think I said, but but your description of standard picture and Scrivener's error is entirely congenial to me. I think the standard picture is wrong, but not for that sort of reason. Larry, you said the intended meaning of the words is the law. That's not what you meant. You don't mean the intended meaning of the words. It's probably the assumed meaning, but not just assumed meaning of the words, because you are a pragmatist. I mean, about language and about meaning. So you want to say something like the propositions that the authors intended to communicate by means of the words they used makes out the law, something like that. That's a view. That's a view. You're entitled to it.
It's nice to know we are all intended to a view, and my view is that this is a great paper. That was a great response. This was a wonderful panel. Thanks to everybody for being a part of it.
Thanks, Tom. Thanks, Will.